Good afternoon. My name is Bob Bennett. I represent Dr. Hall. We've called this press conference so that the public in Houston, the Harris County District Attorney's Office, and those who are also charged with crimes involving Mr. Lonnie Blevins will know that the present District Attorney, Mike Anderson, and his assistant, Denise Nichols, have done the right thing in dismissing the case against my client, Dr. Tony Hall, against Vivian King's client and Jules Laird's client, and also Judge Morris Overstreet's client, State Representative Ron Reynolds, and David Lee's client, Adrian Anderson. This has been a terrible, terrible experience for our clients, and finally justice has been served by today, when Jules was in court, getting the judge to sign the dismissal. So this first step has been accomplished. The case is over. They're not going to go forward with an indictment. Truth has prevailed and justice has been done. However, there are still questions that need to be answered about why, under the prior district attorney, this has taken almost a year to be investigated. What really was the purpose of this barratry investigative unit headed by Wendy Baker and this now reprobate Lonnie Blevins? And so we're here to ask for further investigation, whether it's by the U.S. Attorney's Office, further investigation by the District Attorney's Office that's presently in office, whether it's going to be the Office of Chief Disciplinary Counsel looking into prosecutorial misconduct, or whether we need to file a civil rights action to make sure that we are properly compensated, we being all three defendants who've now been dismissed, for the tens of thousands of dollars they've spent trying to show that they are innocent victims of a witch hunt. Jeff Wagnon, who's standing to my right, was part of the litigation team and played a very valuable role in making sure this case was done. So where do we go from here? There are a couple of things that will still be ongoing concerning this case and ongoing with the Harris County District Attorney's Office. One, all three defendants will be seeking expunctions of these arrests. When we've talked to the District Attorney's Office, we don't get a firm commitment that they will go forward with an expunction. They haven't said no, they haven't said yes. Maybe they're still trying to make a decision what's the right thing to do about an expunction. But all three co-defendants are united in expecting the district attorney, the present district attorney, to do the right thing and have these arrests expunged. There may be further investigations that I talked about. Also, there's still some discussion about a civil rights lawsuit. That's still under consideration. We only got this signed this morning for all three co-defendants, so we're still trying to do what's right for our clients and the legal system. So with those introductory remarks, we're happy to take questions, concerns, or observations that you might have.
What was the catalyst for this case? What did they think they had?
Well, they thought they had a chiropractor, a health marketer, and an attorney who had conspired to commit barratry, which is unlawful solicitation, unlawfully going after clients. The old adage, of course, the old story is that somebody is in a car wreck and a runner comes to that person and says, "Go hire Bob Bennett and he'll take care of you." I pay the runner to do that, and the client comes to me and then I handle the case. That's a barratry case. That's illegal. I sometimes wonder why the insurance industry can go to that injured person and do anything they want to, and plaintiff's attorneys can't, but that's not the issue. But what happened here is that you had a random phone call made. A female attorney by the name of Marcella Hamagen show up undercover with Lonnie Blevins and try to entrap both Dr. Hall and Ron Reynolds into committing barratry, which they weren't doing. They had a legitimate business plan, a legitimate business practice, and what they did, they being both Wendy Baker, Lonnie Blevins, and this attorney, was wrong. And I think, thank goodness, Judge Anderson looked at this, saw that we had established there was no barratry. We filed numerous motions. Jules filed numerous motions. David Lee filed numerous motions, brought it to their attention that this was not Barratry, you couldn't make the case. And then the icing on the cake, or as we say in Louisiana, the lagniappe, was what happened with Lonnie Blevins. Your chief investigator, the person who signed the arrest warrant, the person who signed the search warrant, the person who was the undercover agent, is now sitting in federal prison 3 blocks from here, charged with interstate fraud and theft. So you put all that together, the hard work of the attorneys, the innocence of the people, and a rogue investigator, it came together, and finally the district attorney did what was right. One of the questions that was asked was what was an expunction and what was involved with that. And an expunction is, under the laws of the state of Texas, the ability to eradicate or to make sure that an arrest record is taken care of. In this particular case, and under this present statute, if the district attorney joins or files a motion to expunge a record, then that record is completely sealed, and it's actually a criminal offense if anybody tries to find out about that record or reopens it. So we're continuing to press for our client to make sure that the expunction is done, and done as soon as possible. We hope it'll be done for Adrian Anderson and also Ron Reynolds, but we'll be filing this week a motion to expunge the arrest record of our client, Dr. Hall. Any other questions?
Question I have is since the case was dismissed before it ever was taken to the grand jury, is it your opinion that the district attorney will be joining your petition for an expunction, an erasure of all the...
The law as it stands right now, that if a expunction is joined or filed by the district attorney, it's automatically granted. I can't imagine a situation where a judge would refuse to do that. And our preference would be to enlist and try to encourage, because Anderson and the other assistant district attorneys under his administration have basically been so good about getting this case taken care of, we hope they'll join us. And so that's the best we can say right now.
So you have a meeting scheduled with Scott Durfee, who handles that sort of thing at the office?
We will do that. We'll try to talk to the corporate counsel for the Harris County District Attorney's Office and get that going. We also are representing Ali Mokaram and attorney Peyton Momeni, and Mr. Wagner is working on those parts of the case involving Mr. Momeni, and he'll address where that case is going now.
With respect to Mr. Momeni, he was the subject of a state bar disciplinary action when he was originally charged with Barratry, and the Office of Chief Disciplinary Counsel tried to suspend his law license. To be able to do that, they had to prove under a civil standard that Mr. Momeni had actually committed Barratry. Unfortunately, they were unable to prove, even under a civil statute, that Mr. Momeni had done anything wrong. And Judge Sandhill in the 127th District Court issued findings of fact and conclusions of law that specifically set out what they failed to prove, and that they failed to prove that he had committed Barratry in any respect. It's unclear to me how a district attorney's office could try to continue to prosecute this gentleman when they can't even determine that he committed Barratry under the lowest possible standard. Based on that, we're going to present that information to the district attorney's office regarding the related civil proceeding and see if we can be instrumental in helping Mr. Momeni and Ali Mokaram, who is charged with the same facts, get those cases dismissed on their behalf.
Jeff, would you give a little thumbnail as to the difference in standards between civil and criminal?
In the civil context, all that has to be proven to establish liability, I guess, is a preponderance of the evidence. If you think about that on a scale, the scale of justice has to weigh heavily towards finding fault or liability or culpability. With regard to the criminal standard, it's beyond a reasonable doubt, which means that they have to prove much more, and the standard is much heavier to prove a criminal case, obviously because liberty is at stake.
We really feel strongly that once former Judge Mike Anderson and Assistant District Attorney Denise Nichols are presented with the findings of fact that were signed off on by the judge in the civil case. Once she sees these findings, they will strongly consider dismissing the case against Ali Mokaram and Payman Momeni. In addition, we'll continue to work with all of our clients, which includes Ron Reynolds, Ali Mokaram, Payman Momeni, and other attorneys, to make sure if any action is taken by the Office of Chief Disciplinary Counsel, if they try to go after their law license or file grievances or in any way try to go after them for ethical violations, we will certainly take a very strong stand against those actions. And that's something we'll be very vigilant about for the future, along with also maybe, and this is a maybe because we haven't really finalized our strategy as to further investigation, but certainly we feel that the U.S. Attorney's Office, the Office of Chief Disciplinary Counsel, the County and District Attorneys Association of Texas should look at, including the Department of Justice, should look at what had happened under Pat Lykos in the District Attorney's Office with rogue investigators and what appears to be prosecutorial misconduct. So with that, we thank you for being here today. We certainly appreciate all of you lending your help and support so the public knows what's going on with the District Attorney's Office, what's going on with Barratry. And if you have any further questions, we'll be happy to answer those, or you can contact us at the email and address given below on this video. Thank you very much.